Hello everybody. So in this section we're going to look at somewhat of a, it's not necessarily a relatively new area of school law, but it certainly has made a lot of news in the last couple of years, and that is gender discrimination among students. And so we will obviously talk about the transgender issues that are going on in the country right now at the end of this, but there is some good information in the beginning as well as the transgender information that certainly as an administrator you need to understand. And as we'll see, a lot of this is going to obviously involve Title IX and the Equal Protection Clause of the 14th Amendment. So let's take a look at this. Now, I will add that I do think that part of the most recent issues with transgender is what included this as a whole chapter in your textbook. Keep in mind that whenever I'm quoting anything in here, and many of the slides are direct quotes out of Alexander and Alexander. So with that, the first quote we see here is actually one that we're going to finish with. And that says, education in America reflects the norms of society. If society is unjust, then the educational system is likely to be also. And this is an important quote because it's going to tell us a lot of what rationale is behind the courts and their decisions when it comes to gender issues. And this doesn't just start with transgender, even though that's obviously the most popular thing in the field right now as far as gender issues. It goes back to a lot to do with Title IX. So what we're really looking at here are two things. Title IX of the Education Amendments of 1972, and more importantly, the 14th Amendment. Remember I said at the beginning of class that everything that the Supreme Court hears has to deal with a constitutional issue. And so when you listen to a Supreme Court argument or you read a decision or an appeal, everything goes back to how this is a constitutional issue. And so here we're looking at the 14th Amendment and specifically the Equal Protection Clause of the Constitution. Does it apply? Does the law apply equally to all participants? And then we're going to use Title IX as the law that we're discussing. So just a little bit of background. Now, Title IX came in 1972, but you can see in 71, the courts made a decision in Reed versus Reed. And in this decision, they obviously looked at the 14th Amendment because Title IX wasn't in place. But the 14th Amendment, the court struck down the state statute because it gave preference to male over female. It was considered in violation of the Equal Protection Clause. So here we're striking down laws that simply gave preference to male over female. And you can imagine how much this can be reinterpreted as we go on. And keep in mind, subsequent decisions based on Reed are going to clarify points and bring out more points here, okay? One important thing to consider, well, actually a couple of things, is this, of course, in the early 70s was the time of the women's rights movement going on in the United States and the Equal Rights Amendment in the United States as well. So there are a lot of issues. It's not a surprise that we see this moving into education as well. But in 1971, when the court ruled in the Reed case, gender was not as scrutinized as race. And what we mean by that is that after Brown and then the Civil Rights Act of 1964, race, in order for a state to discriminate against race, it had to show a compelling interest for the law. In 1971, though, even though the court struck down this law in California, the states only need to show the law was rational and not capricious in its beginnings or applications. Okay, so there's a lower standard at this time uh, for that would allow states to have gender discriminatory laws. Nonetheless, uh, this case is significant because the court did show that discriminatory laws can violate the Equal Protection Clause. That idea of rational and non-capricious was leveled up in the 1976 case of Craig versus Bourne. And here the Supreme Court changed the wording. So you can see this comes after Reed and reference Reed, but said that the decision in Reed didn't go far enough. And here the state must show in its rationale for a gender discriminatory law that it serves an important governmental objective. Or ask the question, does it serve an important governmental objective? And so you can see these with the backgrounds then for what we're going to take into education. Okay, the 14th Amendment to the Constitution, Reed, and then in 72 Title IX, and then ultimately in 76, stating that there has to be an important government objective for there to be discriminatory laws. So let's look now at specifically dealing with schools. And most of this is going to deal with Title IX and the various aspects of Title IX. Some of the first rulings that came down with Title IX dealt with school admissions. And here we see that schools are not allowed to discriminate on admission standards based on gender. And schools also cannot have separate criteria for boys and girls for admissions into schools. And that case was an interesting case because what had happened is the cut scores were different for boys and girls, so that the final product would be 50% boys and 50% girls in the school. And so in trying to do that, the school had good intentions of creating this balance. But in creating that balance, the court said that it's actually discriminatory to have the separate criteria for boys and girls. So schools have to allow other genders to apply, but yet at the same time, you cannot have different criteria for one or the other. And I actually talked not about this specifically, but was talking about in Denton, Texas, where Texas Women's University is. And I worked with a colleague recently who's from Denton, and I said, you know, they do allow men in there. And she said, of course they allow men in there now. Doesn't mean they're going to change the name, but they do allow men. She said they have a healthy male population, even though the name is still the same. So anyway, that's just some basic background. Mainly what we deal with as administrators and gender issues are going to be with athletic teams. Okay, so athletic teams, here's what the courts have basically ruled when it comes to Title IX. Girls must be allowed to compete in non-contact sports. Various states have ruled that girls must also be allowed to compete in contact sports, especially if that sport is not offered, or primarily if that sport is not offered in a girls' version. Okay, the reverse, though, is not necessarily the case. In other words, boys guaranteed the right to compete in girls' sports. And the ruling there, the rationale behind saying that girls have to be allowed to compete in boys' sports, such as playing football and allowed to participate in football, does not apply in the reverse. Boys being allowed to participate in girls' sports, maybe such as softball, if you had fall softball and didn't have fall baseball. And the ruling there is that the whole purpose of athletics is to help build up the self-image, the camaraderie of an individual. And while girls may not necessarily get into a sport and dominate it, the reverse of that could very well be true, that boys, simply because of their physical stature, could get in and physically dominate and take girls out. So that's the rationale behind why the courts say that boys are not necessarily guaranteed a right to compete in girls' sports. Looking still more at athletic teams, the courts have 3 criteria to consider for an equal protection violation. So the first criteria then is the character of the classification. Is the decision by the school based on gender or not? In other words, can a female participate in an athletic event or not participate in an athletic activity simply because of her gender? If that is the case, then they move to number 2. Number 2 states the individual interests affected by the classification. In other words, are there educational benefits to be gained or lost? And again, I said that the courts have ruled that there are educational benefits to participating in extracurricular activities. And then finally, the third thing here is that the government interest asserted in support of the classification. In other words, why is the government or the school putting forth this policy? And so one of the rationales used here was the girls had wanted to participate. I believe it was football. And the school said no, they cannot participate in football. It would be harmful to them. They could get seriously hurt. So, number 1, yes, it was based on gender. Number 2, could there be a benefit? Yes, it could be a benefit. Number 3, why did the school put forth this policy? The school stated it was to protect their physical well-being. They could be seriously hurt. And what the courts had ruled was that because the sport was open to all boys, and that even the weakest among the boys could participate in the sport, whether they played or not, that girls wanting to participate would most likely fall into the spectrum somewhere between the weakest boys and the strongest boys, and therefore it violated their rights, their equal protection rights, by stating that they were banned from playing because it would hurt them. So just an interesting rationale. As an administrator, I'll tell you, I had a couple times I had girls who wanted to go out and play middle school football. We obviously did not have a counterpart to middle school football for girls, and so we let them do it. And while they both enjoyed it, neither one of them stayed on the team, and nothing came of it. Okay, so keep this stuff in mind as you're an administrator. These are real life things that you most likely will deal with at some point. So Title IX. Title IX, of course, comes in 1972 forbade discrimination based on gender for athletics, extracurricular activities, financial aid, testing, curricular offerings, pregnancy, and marital status. Some additions, some clarifications to Title IX, and how it could be applied. So that was 1972. 12 years later, in 1984, the courts ruled that in order to be in violation of Title IX, then the program that was in question had to be receiving federal funds for it to be considered a discriminatory program. And you can see how this is going to be reinterpreted. In 1987, the Civil Rights Restoration Act of 1987 apply Title IX to any program within an institution that receives federal funds. And this change not only applied to students but to employees of the institution as well. Keep in mind, Title IX is going to be used for sexual harassment. We're going to look at some wording on Title IX in a minute. So we went from 1984, the interpretation that Title IX violations only impacted programs that were using Title IX funds. Then in 1987, Title IX infractions were expanded to any program within an institution that received Title IX funds, or I'm sorry, received federal funds. Okay, I've been saying Title IX funds, I mean federal funds. And then finally in 1992, up until this point in 92, the penalty for violating Title IX would be the loss of that money. Okay, but in 1992, in the case of Franklin versus Gwinnett County Public Schools, which is in down in Atlanta, the courts ruled that monetary damages for intentional violations of Title IX could be issued. And so that's going to be a big warning to you as a future administrator that if violations are intentionally ignored, then monetary damages will come into play. So one of the ways then to get around Title IX issues is what we call comparability. The intentions is not to open up boys' teams to girls. Teams must be offered on a comparable basis for students for both genders, taking into account the interest and ability of both genders. For example, if your school offers baseball and offers, if you, let's say you're in a small school, I'm going to give you a simple example here, but you're in a small school, you have basketball open to everybody. This was my typical schools growing up, and in my early teaching career, they were small enough that we offered basically two sports, basketball and baseball. Basketball was open to everybody, baseball was open only to boys. The comparability aspect here then is saying that boys have the opportunity to participate in two events and girls have the opportunity only to participate in one. And so comparability would mean that you could take the route of opening up baseball to girls, or you could offer a sport comparable to baseball. And so quite often in small rural schools in Oklahoma, you will see basketball offered to boys and girls, baseball offered to boys, and volleyball offered as an alternative for girls. Okay, and so that's what comparability is. Standards reviewed to determine if teams are comparable. So once you do that, once you decide, I'm not going to open up baseball, I'm going to open up completely separate girls volleyball and let girls participate in volleyball. Once you do that, then the following 8 criteria apply. The selection of sports and levels of competition effectively accommodate the interests and abilities of both genders. If you have competitive baseball, then you need to have competitive volleyball. You can't just say, I'm going to have a girls volleyball hour. It needs to be a competitive sport. Okay, that's level of competition. A provision for equipment and supplies. As an administrator, you want to make sure that everything is on a nice rotation, that you purchase similar equivalent equipment and supplies for teams on a formal rotating schedule, including both girls and boys sports as you go, scheduling games and practice times. Here I'll give you an example of this. I had a dad come to me once, and I think he was somewhat joking when he told me, he said, you know, it's really not fair that girls have to practice in the morning and boys have to practice after school. He said it seems a little bit more dangerous that the girls are out in the morning driving when it's dark and the boys are free. Like I said, I don't think he was necessarily serious about that, but we had to take that as a serious contention, and sure enough, what he said was very true. And so as a result of that, we changed practice times for boys and girls to all athletics were all last hour of the day. So that's what we mean by scheduling of games and practice times. Travel and per diem allowances, opportunity to receive coaching and tutoring, assignment and compensation of coaches, um, provision of locker rooms, practice, competitive facilities, and then finally medical and training facilities and service. All these things have to be equivalent, or you're going to be in danger of violating comparability of Title IX. As far as accommodations go for Title IX, there are 3 accommodations. So one thing to keep in mind is opportunities for male and female students are provided in numbers proportionately to enrollment. Okay, if you have a significantly greater number of female students, then you might get away with offering only 1 male sport versus 2 female sports. Okay, um, so those simple opportunities equivalent to the proportional number of students, that's the key thing. Athletic participation opportunities are proportional. And then once these things are determined, the court looks at everything on a case-by-case basis and the specifics of each school to determine if Title IX accommodations have been made. So another place where Title IX comes into play that we generally don't necessarily think of is the area of sexual harassment. We tend to think of Title IX as being an athletic issue or access for girls to things. But Title IX also covers sexual harassment. Sexual harassment is defined as the unwanted imposition of sexual requirements in the context of a relationship of unequal power. And based upon that definition, we have 2 categories: quid pro quo, whereby the person in power extends some type of reward for submission. And here we're usually talking about teacher-student relationships, where a teacher may promise a student extra grades or extra support in a class or extra participation on a team. The other side of sexual harassment is the hostile environment side, where there is no quid pro quo, and it simply creates a hostile, offensive, or intimidating environment for the student, where the student is simply asked by an unequal power for something and receives nothing in return. Either way, they're obviously illegal, okay? But just to show you, there are two categories then of sexual harassment. Sexual harassment does not need to be between a teacher and a student. It could be between student to student, okay? And this is what we call peer-to-peer peer-to-peer harassment. And this would be when students are harassing, and peer-to-peer does not necessarily mean boy to girl. It could be boy or girl to girl, okay? And in 1999, the court, through the Davis case, established the Davis test as a 3-part test for peer-to-peer sexual harassment. And this test says, number 1, plaintiff must show that there was, in fact, sexual harassment by peers. And the text talks about it's actually boy-to-boy sexual harassment in the text, derogatory slang terms, and physical pinching and things like that. So there was definitely sexual harassment involved. School officials or teachers must have had actual knowledge of the harassment, and the harassment must be so pervasive, severe, and objectively offensive that it deprives the victim of access to educational opportunities. So there are some important things here, because the chances of you dealing with sexual harassment case among teacher to student are lower than dealing with sexual harassment case from student to student, peer to peer. Okay, and so and then keep in mind here, as we said earlier, as of 1992, monetary damages can be issued as a result of this, because this all falls under Title IX of the federal law and has the backing of the 14th Amendment. So if you, as an administrator, have knowledge that something may or may not be happening and you do nothing about it, then you are going to fail this test here. Okay. If you investigate and you find that it is not pervasive, severe, and objectively offensive, depriving the victim of an educational opportunity, then you have cleared yourself. But if if it were to go to court and rule that yes, this is depriving the student of their educational opportunity, and you knew about it, then you are going to be held liable. And according to Franklin, you could pay monetary damages as a result of that. I'll give you an example of something that happened. I had a student come into my office, and this particular student had issues, and I'd worked with this student through numerous issues. And then out of the blue, the student came into the office and said that a male student, this student was female, a male student had tried to put his hands in her back pocket of her jeans. And I knew that this male student particularly did not like the female student. And so I thought, my first thought was, if he did, it wasn't a sexual harassment thing. It was probably more of just being mean to her, but I had to investigate. So, and thank goodness we had cameras. So here's the thing. The cameras are in the hallway. We've ruled that cameras are legal in hallways and in classrooms, though we didn't have them in classrooms. We had them in the hallway. So what the camera showed was the female student, the class end, the male student went up to the teacher's desk. The female student went up into the class, and you could see that on the camera, up to the teacher's desk. And even though the camera was not in the classroom, the teacher's desk was positioned so that you could see part of the female as she was standing in front of the teacher's desk. She was standing at such a point. And I'll add, there was a substitute teacher this day as well. And so from the moment the female entered the classroom until she left, there was no loss of sight of her. But I did see the male student eventually come out. So I could tell that the female student had gone in and went to the teacher's desk. The male student who had been standing at the teacher's desk came out. And anyway, through investigation, the substitute teacher said there was nothing that he noticed happened at the desk. There was nothing on the video that indicated something had happened. The female student had continued to stand at the desk even when the male student had left the room. And there were no prior incidences of anything such as this between these two students. Again, they couldn't really stand each other. And so based upon that and showing the parents the video, I told them that I honestly didn't believe that this happened, and that if it did, it was an accident, and that it was probably misinterpreted as sexual harassment, that the student really just bumped against the person. And anyway, that's a little bit of a long story to explain how this Davis test worked. But the bottom line is here, you have to investigate. If you do not investigate, then that is called what the courts have stated as deliberate indifference. And this comes out of the 98 case of Gepser versus Lago Vista Independent School District. If the district willingly knows that something has happened and fails to investigate, or is made aware that something has happened and fails to investigate, then they will be held as being deliberately indifferent to the situation, and therefore will be found liable and could very well pay monetary values as a result. So, a quote from the book: school districts would well be advised to provide in-service sensitivity training regarding sexual harassment for both teachers and school administrators that includes documentations of warnings and warning sign of such behavior between employees to employees, employees to students, and students to students. And this is just making sure that all your faculty are aware of what sexual harassment is, and that it will not be ignored. So anyway, that's a long story kind of explaining it, but it's becoming obviously very important. So I said that we have a lot more now dealing with transgender bathrooms, and that's usually the first thing now that comes to mind when we talk about gender discrimination. But through the other stuff, you can see there's actually a long history of gender discrimination. And while a lot of it centers around athletics, and we're moving into this new area of transgender, there are other issues as well. But speaking specifically of the transgender, so here's what has started all this. In spring of 2014, the Office of Civil Rights out of the United States Department of Education stated, Title IX's sex discrimination prohibition extends to claims of discrimination based on gender identity or failure to conform to stereotypical notions of masculinity or femininity, and OCR accepts such complaints for investigation. Similarly, the actual or perceived sexual orientation of gender identity of the parties does not change a school's obligations. Indeed, lesbian, gay, bisexual, and transgender or LBGT youth report high rates of sexual harassment and sexual violence. So this is what started the gender bathroom issues. And this, I'm sure, will eventually get to the courts. But right now, the two cases reported at the time that our textbook was printed, one in Maine and one in Colorado, have ruled in favor of the transgendered students. Okay, and the last line in the book by Alexander and Alexander, or the last line in the chapter, the bottom line of the law is that sexual identity is a protected civil right. And while some may not agree with that, that is the direction in which society is moving. Okay, and so as a result of that, we are progressing, and hopefully we're not going to regress backwards, but continue to progress forward. So as a result of that, earlier I stated that we would see the same quote at the end of this presentation that we did at the beginning. So here is that quote again. Education in America reflects the norms of society. If society is unjust, then the educational system is likely to be also. And so hopefully my philosophical piece here, for what it's worth, as society evolves, so our norms will also evolve. And I think that's just a common thing that's going to happen. And so as our norms in society evolve along with society, then our educational systems have to evolve as well. And that's where you're going to see these continued struggles with gender identity, gender discrimination in education for the next few years, I think, is dealing with that issue that we just looked at, the LGBTQ issue. So with that, that's a quick look at gender discrimination and all that it encompasses in our text.